the key presenter, Dr. Short. Let me apologize for being late after Parliament sat and adjourned. I needed to have a meeting with my caucus because, admittedly, these are not normal times. And I know the Honorable Kujetu and associates are fanning the embers, so I must always be on the lookout. That's in a lighter vein. Mr. Chairman, I think, Professor Chairman, I think even though I came in late, I caught the tail end of the presentation of Justice in the Short. I must say ordinarily that I have nothing useful to add because I just opposed it with my own presentation last week. I think that we are on the same page. So I agree with the presentation that you have made. The other day, I provided a bird's eye view into all the areas. I attempted at least to do that. You have narrowed your presentation, and as I guess it's been indicated to you, to focus on the excessive powers of the president. I agree. The other day, I agreed with the position of Nana Dr. Kyei-Mensah-Bonsu that we have created a constitutional monarch for ourselves, and we need to confront the reality. And I think that we should be engaging in a holistic review of our constitution. I don't want a situation where people begin to talk about tinkering with the constitution, and as I hear some people say that, oh, let's implement the Constitutional Review Commission's recommendations. I agree that that indeed should constitute a major source of reference for us. But we must all admit that what they did is unfortunately inadequate given the circumstances that we find ourselves in. But it cannot also be an exercise in futility what they have done. My little point of departure, though, has to do with the emphasis that when you appoint ministers from Parliament, it may amount to a conflict of interest, serving as ministers and also as legislators. I share a different opinion because we have the Westminster system where all ministers are appointed from Parliament and they do a good job. I think the reason why our own is not working well, we must admit, the US is the flagship of presidential systems. Ministers are appointed from outside Parliament. The ministers add value to governance because all of them who are appointed to various positions are experts and they add value to wherever they serve. In the Westminster system, the established Westminster system, for a person to be appointed a minister, that is, members of Parliament to be appointed ministers, they would have served in particular committees, perhaps risen to become shadow ministers. And there's nothing relating to that sector that a person would not know. So if a person is appointed a minister from Parliament, he knows his bearings. And there's nothing that we can hide from him. Indeed, in France, for instance, the Committee on Finance is chaired not by a member of the ruling party, but a member from the opposition party, just like the Public Accounts Committee. When I asked, they said the Finance Committee is the fulcrum of governance, and nothing should be hidden away from the minority, that's the opposition. So members of Parliament who become ministers of state, when their party wins, are well enamored. Unfortunately, in our situation, we're having challenges because here we have presidents and all presidents who come, they appoint members of parliament as ministers, deputy ministers. They are not experts in the fields where they are appointed to, first timers, and they have no knowledge of the sector that they are being appointed to the extent that at the appointments committee, when fundamental rudimentary questions are asked to them, they are not able to respond. And they tell you that, oh, please, I'm not there yet, you approve of me, let me go there, I will learn. Learn what? The Constitution provides that a minister of state should assist the president in running the state efficiently. And if you're a cabinet minister, you should be assisting the president to evolve policies in your sector. And the person is telling you that, let me go, I will learn. What assistance is he going to provide the president? We are falling foul because of our own ineptitude. Ineptitude on the part of parliament, and maybe, as you said, because of maybe the president also has to satisfy his base. So all manner of people are appointed. So I think it's something that we should be looking at. My preference, if you ask me, is the Westminster system and not the presidential system. We are talking about the investiture of supreme power in the president. It's not so in the Westminster system. Fancy the situation we are in, and I'm just citing this as an instance. Maybe it should be up. Sometimes, as somebody said, I'm not afraid, but I feel small. Look, where we are, if it had been in the Westminster system, my colleagues are raising issues about maybe the censure on the Minister for Parliament and Minister for Finance. Even the Westminster system, Parliament will take the issue, and the next day he's not there. I'm not in any way justifying what they are doing. I have my own reason, but I'm saying that I'm not here justifying it. But I'm just saying that if this matter were to be in the Westminster system, the logical conclusion would have been reached. And the majority leader in the Westminster system is the Prime Minister. The majority leader just tends his or her own constituency. Even in these days of excessive monetization, look at how much member of parliament will be spending in his own backyard. Compare that to what the president spends. No president would dip his hand into the national to reward people who might have supported him. But that is where contracts, when they are awarded, corners are cut. We all do know. And we saw the seeds of corruption in our own system. Look, from the selection of parliamentary candidates, what happens in our backyards? What happens in our backyards? We all do know, and yet we pretend that people are only being given drinks and cola. Kujetu and I know that it's not drinks and cola, it's something else. We saw the seeds of corruption there in the way we even select our parliamentary candidates, right up to the selection of presidential candidates. And we pretend everything is right with us. We can't fight corruption to the extent that the system we are operating continues. That is the bottom line. And the political parties must also be engaged. In any established system, members of parliament are assessed by their peers in parliament. They perform well, there is nothing untoward in their backyards, And to that extent, they are continued by the political parties. Here, every 4 years, the sluice gates are opened, and, the contest, unfettered contest begins there. People come to Parliament, and they are in debt. You think they should not be looking for appointments? If their party is not in power, they find out, they go looking for contracts. If their party is in government, they do not have ministerial or maybe deputy ministerial appointment, they'll be banging the doors of the president. Can you take me to this board? I want to belong there. And when he has recouped his monies, he's looking for the next elections. So he must also not only restock his arsenal for the next battles, but again, what he has lost, he must make good what he has lost. We must be pragmatic with ourselves. So, Justice, I think I agree by and large with what you have said, and I was saying to ourselves that the budget, we anticipate the budget maybe on 15th or maybe the next 2-3 weeks. The Constitution provides, and we're talking about strong financial control. The Constitution unfortunately provides in Article 179, Clause 2. Let me quote. The estimates of the expenditure of all public offices and public corporations, other than those set up as commercial ventures, A, shall be classified under programs or activities which shall be included in the bill to be known as the appropriation bill, and which shall be introduced in Parliament to provide for the issue from the consolidated fund or such other appropriate fund of the sums of money necessary to meet that expenditure and the appropriation of those sums for the purposes specified in that bill. Then it shall, in respect of the payments charged on the consolidated fund, be laid in Parliament for the information of members of Parliament. What it means is that the Constitution provides for the budget to be introduced in Parliament just for our information, not for our consideration and approval. That is the 1992 Constitution. So what do we expect Parliament to do? What we are doing, the approval of the budget that we do, is by convention and practice. It's not backed by law. Unfortunately and interestingly, when you come to, I think it's the supplementary estimates, that is Article 179(8), it says, where in respect of a financial year, it is found that the amount of money appropriated by the Appropriations Act for any purpose is insufficient, or that a need has arisen for expenditure for a purpose for which no sum of money has been appropriated by the Act, a supplementary estimate showing the sum of money required shall be laid before Parliament for its approval. So whereas Parliament is clothed the authority to interrogate the supplementary estimate and approve of same, for the main budget is only for the information of Parliament. That's the Constitution that we have given ourselves. And that is why I'm saying to us that indeed and in truth, we must be careful. Just today, the minority leader had filed, the minority, I should say, not the minority leader. They filed a motion of censure on the Minister for Finance. A motion of censure by our own provisions, Article 82 provides, and I was telling them that we should be a bit careful about these things, because Article 82 provides that Parliament, by a resolution supported by the votes of not less than 2/3 of all the members of Parliament, pass a vote of censure on a Minister of State. Now, Clause 4 of Article 82 says, a Minister of State, in respect of whom a vote of censure is debated under Clause 3 of this article, is entitled during the debate to be heard in his defense. That's a right. He must be heard. What if the minister elects to be heard not by himself, by his counsel, the lawyer will not be entertained in the plenary. And yet, this is what we have. Now, just oppose that with what obtains in Article 69, Clause 7, which says the president shall be entitled during proceedings to be heard in his defense by himself or by a lawyer or other expert or person, as the case may be, of his own choice. So whereas the president is given this opportunity to be heard by his counsel, the minister no. So a minister cannot elect to be represented by his counsel. How justified is that? And Article 12 of the Constitution provides the fundamental human rights and freedoms enshrined in this chapter. Fundamental rights and freedoms, including the right to be heard by your counsel. Right? The right to be heard through a counsel, I should say, shall be respected and upheld by the executive, the legislature, and the judiciary, and all organs of government and its agencies. The legislature is required to accord this right to any person who otherwise is cited to appear before plenary. How do you do this? Is that just to the person? So, Justice, I began by saying that I have nothing useful to add to your presentation. These are mere anecdotes. Professor Chairman, thank you very much for the opportunity.